Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the Rhode Island Data Transparency and Privacy Protection Act and its key requirements. This law strengthens privacy protections for Rhode Island customers by requiring businesses to be transparent about how they collect, use, share, and sell personal data. Here's a quick timeline. The law was enacted without the governor's signature on June 28, 2024, and takes effect on January 1, 2026. The Act applies to for-profit entities doing business in Rhode Island that process data of over 35,000 customers, or at least 10,000 customers if more than 20% of revenue comes from selling personal data. Exemptions include government agencies, nonprofits, higher education institutions, and data regulated under federal laws such as the Health Insurance Portability and Accountability Act or the Gramm-Leach-Bliley Act. Businesses must designate a controller when acting as data sellers, disclose data categories and third-party recipients, maintain reasonable security measures, obtain consent for sensitive data, honor revocation within 15 days, execute contracts with processors, and conduct assessments for high-risk processing. Commercial websites and internet service providers that collect, store, and sell customers' personal data need to identify the categories of data they collect, disclose all third parties that receive that data, provide a way for customers to contact the controller, and clearly disclose whether the data is sold or used for targeted advertising. Additional requirements include authenticating customer requests, offering an appeals process, having no obligation to re-identify data, and overseeing how recipients handle de-identified information. Customers can confirm if their data is processed, access or correct it, request deletion, obtain a portable copy, and opt out of sales, targeted advertising, and profiling. The Rhode Island Attorney General enforces the Act. There is no private right of action. Violations are treated as deceptive trade practices with civil penalties of up to $10,000 per violation, plus separate fines between $100 and $500 for certain intentional disclosures of personal data. Thank you for joining us. At Climb, we're here to help you navigate compliance with ease. Visit us at climb.io to learn more about our all-in-one digital compliance solution.